Unfortunately, having a will doesn't mean your family avoids probate. Probate can drag on for months or even years, tying up your assets and leaving your loved ones stuck in a legal mess. In this video, I'll explain what probate really is, how long it usually takes in Texas, and simple ways you can avoid it so your family can get what they need faster and with less stress. Hi, I'm attorney Aaron Miller, and about 15 years ago, I saw how tough it is for families when they lose control of their assets. So I decided to dedicate my career to helping people plan and protect their future. If you'd like to speak with a trusted attorney, give us a call today at 214-292-4225. All right, let's get started with the basics of probate and why it's crucial to understand how it works. The probate process. Probate is basically the court's way of making sure a person's estate is handled properly after they pass away. It all starts when someone files what's called a petition with the court. The court first checks that the will is valid, and if there's no will, Texas state law steps in to decide how the assets get divided. Then the court appoints a personal representative. Now, usually that's the executor named in the will, or if there's no will, it'll be someone else. This person's job is to gather up the assets, pay any debts and taxes owed, and then distribute what's left to the heirs. Now, while probate is designed to make sure everything's done right, it's not always quick. It can take several months to over a year, especially if there's disagreements or complicated assets involved. Reasons to avoid probate. Probate may be designed to ensure fairness, but in reality, it often creates unnecessary burdens for families. The process can drag on for months, sometimes even years, leaving loved ones waiting for access to assets they may urgently need. It's also expensive, with court fees, legal costs, executor fees quickly adding up and reducing the estate's value. But beyond the financial toll, probate can be emotionally exhausting. Instead of focusing on grieving and healings, families are stuck navigating legal paperwork and deadlines. And on top of that, everything becomes part of the public record. Your assets, your debts, who gets what. That can invite unwanted attention or conflict. And if there's any tension or confusion over the will, probate often fuels disputes that can divide families and drag out in court. Strategies to avoid probate. Fortunately, there are several strategies that can help you avoid the probate process. First, living trusts. A revocable living trust is one of the most effective tools to avoid probate. In this arrangement, you create a trust during your lifetime and transfer your assets into it. You can serve as the trustee, meaning you still control your assets while you're alive. And when you pass away, the trust's successor trustee takes over and distributes the assets directly to your beneficiaries, or however it is stated in the terms of the trust. And it does it without the need for probate. The primary benefit of a living trust is that it helps avoid the probate process. Since the assets are owned by the trust, not you personally, they don't need to go through the court process to be transferred to your heirs. Additionally, a living trust provides more privacy than the probate process does because the distribution of assets doesn't become part of the public record like it does to the probate process. Next, irrevocable trust. Unlike a revocable living trust, an irrevocable trust cannot be changed once it's created. While this may seem like a disadvantage, it offers some significant benefits. For example, assets in certain irrevocable trusts are no longer considered part of your estate, which can reduce estate taxes and protect assets from creditors. Some common types of irrevocable trusts include charitable trusts, special needs trusts, spendthrift trusts, or Medicaid planning trusts. These type of trusts can provide specific benefits tailored to different needs, such as supporting a disabled loved one or donating to charity while reducing tax liability, or it could help qualify for government nursing home benefits. There is a joint ownership with right-of-survivorship deed, although in Texas that's extremely rare. Simply having both names on a property deed doesn't automatically mean it will pass to the surviving owner outside of probate. It requires very specific legal language and formalities that most title companies won't use by default. A more common way people pass assets outside of probate in Texas through a right-of-survivorship is through a bank account set up with a right-of-survivorship. If you and a spouse or partner share one of these accounts, the money will go directly to the surviving person without probate. Fourth, transfer on death deeds or ladybird deeds. These type of deeds allow you to pass real estate directly to a named beneficiary without going through the probate process. And because it doesn't go through the probate process, it can also help prevent Medicaid estate recovery. These type of deeds are especially popular because you keep full control during your lifetime. You can sell, refinance, or change beneficiaries later if you need to. Now, all of these tools can help keep your assets out of the probate process, but the real key is choosing the strategy that fits your goals, protects your family, and works with your full estate plan, not against it. While probate serves as an important function in managing and distributing an estate, it's not always the best option for your loved ones. The process can be time-consuming, expensive, and emotionally draining. By taking the necessary steps during your lifetime, you can avoid probate entirely, ensuring that your estate is distributed efficiently and privately without the need for court involvement. However, estate planning can be complex, so it's always best to consult with an experienced estate planning attorney to tailor a plan that suits your unique needs. If you're ready to start planning or you want to understand your options, give us a call today at 214-292-4225. We'll walk you through what makes sense for your situation and help you protect the people who matter the most. And if you found this video helpful, don't forget to like and subscribe. We've got more answers coming your way. Click the next video right here to stay informed.